So hello everyone. Today we'll discuss about the Supreme Court. Basically India, like how it started, what it does, everything about this. So in India we have the integrated judicial system. So it's like at the top Supreme Court, then we have high courts, then beneath the high courts we have subordinate courts. Okay. The single system of court was adopted from the Government of India Act 1935, which kind of enforces the both central laws as well as the state laws. So basically, as we have indicated, so they will handle both the central as well as the state laws. In USA, the federal laws are enforced by the federal court, and the state laws they're enforced by the state judiciary. So they have basically double system of courts, not a single integrated system. So Supreme Court of India was inaugurated on January 20th, 1950. It succeeded the Federal Court of India, which was established under Government of India Act 1935. However, jurisdiction of the Supreme Court is much greater than Federal Court because the Supreme Court has replaced the British Privy Council as the highest court of appeal. So basically, in 1935 law, Federal Court of India was there, but at the top of that, there was one British Privy Council. So Supreme Court has kind of replaced that as well. So now Supreme Court is the topmost judicial body in the India. Now coming to the articles 124 to 147 of the part 5th. So as we talked about part 5th, right, the union which contains the parliament, the legislature, the executive and the judiciary. So in that part only we have article 124 to 147 which deal with the organization, independence, jurisdictional power and the procedures of the Supreme Court. And parliament is also authorized to regulate these things, right? Regulates the procedures and all those things of the these articles which relates to the Supreme Court. Now coming to the composition and appointment. If I talk about this, so at present in Supreme Court we have 34 judges, 33 plus 1 Chief Justice of India. So the number was kind of varying. In 1950 it was like total 8, 1956 it was 10, to 1960 13, 17 in 1977, 25 in 1986, 30 in 2008 and currently it was 33 in 2019, but in currently we are I think it is just about like 33 judges plus 1 Chief Justice of India. Now how the appointment of judges happen? So basically the judges are appointed by President. Chief Justice is appointed by President after consultation with such judges of Supreme Court and High Court as he deems necessary. Okay. तो चीफ जस्टिस के अपॉइंटमेंट के लिए तो ही कंसल्ट्स विद अदर जजेस ऑफ सुप्रीम कोर्ट एंड द सीनियर मोस्ट जजेस ऑफ सुप्रीम कोर्ट और हाई कोर्ट्स. तो बेसिकली उनसे एडवाइस लेगा. एंड अदर जजेस आर अपॉइंटेड बाय द प्रेसिडेंट आफ्टर कंसल्टेशन विद द चीफ जस्टिस ऑफ इंडिया एंड अदर सच जजेस of Supreme Court or High Court as he deemed necessary. The consultation of Chief Justice is obligatory in case of appointment of a judge other than Chief Justice. Because Chief Justice के केस में कोई बचा ही नहीं, किससे एडवाइस लेगा. There is always some controversy over the consultation, like is it compulsory or not. So there was first judge's case in 1982. In that case, Supreme Court held that consultation with the Chief Justice of India does not mean concurrence. It only implies the exchange of views, like it's not binding on the president. Okay. Second judge's case, it happened in 1993. It reversed its first judge's case ruling of 1982 and said now the consultation will lead to concurrence. It's binding on the president, right? It's binding on the president to work on that, to accept the advice of the Chief Justice of India. But the Chief Justice should advise other two consulting two most senior judges of the Supreme Court. Okay. So CJI plus two more other judges on those consultation, the president will have to bind. Then came the third judge's case in 1998. The consultation process can be adopted by Chief Justice. It requires the consultation of plurality of judges. Okay. So basically he should consult a collegium of 4 senior most judges of Supreme Court. And even if 2 judges give an adverse opinion, he should not send recommendation to government. So basically अब CJI का तो पावर चला ही गया. Basically उसने कहा कि एक कॉलेजियम बनेगा 4 सीनियर मोस्ट जजेस का. उसमें से अगर 2 भी उसको किसी पर्सन के अपोजिट ओपिनियन दे रहे हैं उसको जस्टिस बनाने के लिए, तो फिर you cannot go with that recommendation. But why? Then the Chief Justice of India भी तो एक member है. Like if 3-2 is there, then also it should be there, ना. But in that case it was like दो जजेस भी अगर उल्टा ओपिनियन दे दिया, then the Chief Justice of India should not send recommendation to government. Okay. Then came the 99th Constitutional Amendment Act 2014, which was the NJAC, National Judiciary Appointments Commission Act 2014. Basically, it replaced the collegium system of appointing judges of Supreme Court (NSC) with a new body called NJAC. But however, in 2015, Supreme Court declared that 99th CAA and the NJAC Act both are unconstitutional and void. So basically, I think they were taking to grasp the power of the collegium. And so basically, why executives trying to take over the power of the judiciary? Then fair, like interference, you can't interfere with their powers. So Supreme Court said that this law is unconstitutional and it will be void. Okay. Now, appointment of Chief Justice of India. Okay. Now we'll discuss about the entire thing, right? In 1950 to 73, there was the practice to appoint senior most judge of the Supreme Court as Chief Justice of India. But in 1973, we see that A.N. Ray, the Chief Justice of India, he became Chief Justice of India by superseding 3 senior judges. It's the time of the, I think, 1973. If we go through this, there was case 1 and Bharti case, right? So at that time, whoever was judge, he might have given the different decision or different opinion with respect to the executive. Like Indira Gandhi was there as a PM. So I think it is possible just because of that. That's why he superseded 3 senior most judges and made him the Prime Minister, made him the Chief Justice of India, because she might have thought he will be a puppet of the executive. That might be the reason. So in 1973, A.N. Ray was made a CJI by superseding 3 senior most judges. In 1977, M.N. Bay was appointed by superseding 1 senior most judge. Okay. This discretion of government was curtailed in the second judge's case, where Supreme Court ruled that senior most judge should alone be appointed to office of Chief Justice of India. Okay. In second judge's case 1993 में binding तो होगा, that is one thing. CJI is advised to consulting judges. But for Chief Justice of India, only the senior most judge of the Supreme Court, that will be made the CJI. Okay. Now coming to the qualifications. Citizen of India should have been judge of High Court for 5 years in succession, like continuity. He should have been advocate of High Court for 10 years in succession. He should be a distinguished jurist in the opinion of the President. These are the qualifications defined for the to be the judge in the Supreme Court. Oath, he has to take in front of the President or some other person which President may appoint, to bear true faith and allegiance to the Constitution of India, to uphold the sovereignty and integrity of India, to uphold the Constitution and laws, to faithfully and to the best of his ability, knowledge and judgment perform duties of office without any fear of favor, affection or ill will. Now coming to the salary part, it determined the parliament over time to time. It can't be varied in disadvantage except during financial emergency. In 2018, it was upgraded from 1 lakh to 2.8 lakhs for Chief Justice of India and from 90,000 to 2.5 lakh for the other judges. Apart from that, pension 50% and sumptuary allowance and free accommodation, medical allowance, car allowance and all those things are given. Okay. Now coming to the tenure and the removal. Constitution has not fixed the tenure of the judge of the Supreme Court, but they can work till the 65 years of age. And also in meanwhile, they can resign by writing to the President, and they can also remove from his office by President on recommendation of the Parliament. Now, how is this removal process of the judges? Like this impeachment kind of thing, right? So if we come to this, then the resolution is to be passed by the special majority, 2/3 member of the presence in voting and 1/2 of the total members in each house. What could be the grounds? It will be the proved misbehavior in incapacity. So Judges Inquiry Act 1968, that regulates the procedure relating to the removal of judges of Supreme Court by process of impeachment. So first, how the entire process, a removal motion signed by 100 members in Lok Sabha and 50 in Rajya Sabha to be given to Speaker Chairman. Okay. रिमूवल मोशन पहले तो दिया जाना चाहिए टू स्पीकर और चेयरमैन बाय 100 members or 50 members. Speaker chairman may admit motion or refuse to take it. If admitted, speaker chairman has to constitute a 3-member committee to investigate the charges if they are fine or not. This committee will consist of the Chief Justice of Judge of Supreme Court, Chief Justice of High Court and distinguished jurist. So if committee finds he was really guilty of misbehavior or suffering from incapacity, then House can take up the consideration of the motion. After the motion is passed, each House of Parliament, special majority, Address will be presented to president for removal of the judge. Then president will pass an order removing that judge. Till now, no judge has been removed. Only one time, V. Ramaswamy was judge in the 1991 to 1993. This motion was there. Committee found him guilty, but in impeachment motion that was defeated in the Lok Sabha. So he was not getting impeached for that post. Right? Great. Congress party basically abstained from voting in that situation. So acting Chief Justice. So President can appoint a judge of Supreme Court as an acting Chief Justice of India when the office of the Chief Justice is vacant. CJI is temporarily absent. CJI is unable to perform duties of his office. At that time, the acting Chief Justice can be made by the President, can be appointed by the President. And then there are some ad hoc judges. When there is lack of quorum or permanent judges to hold or continue any session of the Supreme Court. At that point, Chief Justice can appoint a judge of High Court as an ad hoc judge of the Supreme Court, but for temporary period. But only after the consent of the Chief Justice of that particular High Court concerned and the previous consent of the President, tabhi you can get that ad hoc judge in your Supreme Court. Judges so appointed will be qualified for appointment as a judge for Supreme Court. Okay, बाद में they can also become the judge of Supreme Court. That's fine. Now coming to the retired judges, so at any time the Chief Justice of India can request a retired judge of Supreme Court or High Court to act as a judge of the Supreme Court. But again, the previous consent of that president and that person is needed. Allowances, he will not be otherwise deemed to be a judge or of Supreme Court as only temporary. मतलब ऐसे इसको जज नहीं बोलेंगे कि जज बन गया सुप्रीम कोर्ट का, देखिए रिटायर होगा तो रिटायर ही रहेगा. Allowances मिलेंगे बट अदरवाइज ऐसे कुछ वो नहीं मिलेगा एक्स्ट्रा पर्क. Now coming to the seat and the procedure. So Constitution declares Delhi as the seat of the Supreme Court. It also authorizes Chief Justice of India to appoint other places as the seat of the Supreme Court, as in judges can sit over there also, but with the approval of President. It's not binding on President. Procedure of court. The Supreme Court can, with the approval of the President, make rules for regulating. Generally, with the approval of Supreme Court, can make the process regarding the regulations regarding the practice and procedure of the court, but with the prior approval of the President. Constitutional cases or references made by President under Article 143 are decided by a bench consisting of at least 5 judges. Okay. So basically saying constitutional cases or references made by President which are under Article 143, I need to look into what is this Article 143. And they are decided by a bench which consists of at least 5 judges. And judgment and all other cases are basically decided by single judges and division benches. But उसके लिए 5 judges का एक bench चाहिए होता है. Let me see what is this Article 143. Just a minute. So 143, powers of President to consult Supreme Court. Okay, I think there is something 143 article is related to when President can consult with the Supreme Court, but also that is not binding, I think. Okay, so that was the case there. So judgments are delivered by open court. All judgments are by majority vote, but judges can have dissenting opinions. So let's say 5 लोगों का bench है, 3 ने हाँ बोला 2 ने बोला, 2 dissent कर सकते हैं, but by majority vote the judgment will be given. Now coming to the independence of the Supreme Court, how do we secure? Mode of appointment. Judges are appointed by the President, basically cabinet, in consultance with the member of judiciary itself, right? It curtails the absolute discretion of executive as well as ensures no encroachment of political pressure. So that is one thing. That is how we maintain the independence of the Supreme Court. Then there is security of tenure. They can be removed by praise only in the manner mentioned in the Constitution. Nothing apart from that. Fixed service conditions, salaries, allowances, everything same. Like उसके लिए सब charge होता है Consolidated Fund of India में, and like कुछ parliament उसमें नहीं कर सकता. Salaries cannot be reduced. The allowances, pensions of judges, staff, and all its administrative expenses, they are charged under CFI. The conduct of the judges can't be discussed in the parliament on state or legislature, on state legislature assembly, except in impeachment motion. ठीक है. Ban on practice after retirement to ensure that they do not favor any person in the hope of the future favor. Power to punish for its contempt, as you can punish any person for its contempt. Okay. Freedom to appoint staff. CGI can appoint officers, servants of Supreme Court without any interference from the executive. CGI का हक होता है appoint staff. Jurisdiction can't be curtailed by parliament but can extend. Okay, jurisdiction को आप कम नहीं कर सकते. That's the right of the judiciary. जितना jurisdiction अभी मिल गया है उतना is there. उससे कम नहीं कर सकते हो, ज़्यादा कर सकते हो. Separation from executive or like executive authority should not possess judicial powers. Okay. Now we will discuss about the jurisdiction powers of the Supreme Court. So basically, it is the final interpreter and guardian of the Constitution, as well as the guardian of the fundamental right of the people of India. Okay. Original jurisdiction में क्या आता है? As a federal court, Supreme Court has the original jurisdiction. It solves the disputes between the central state, and state and state. Basically, central state, state and state. Interstate भी वही resolve करेगा, central state भी resolve करेगा. No other court can decide such dispute at first instance. Only Supreme Court can do that. 2 points. Dispute must not involve a question on which the existence and extent of legal right depend, and any suit by private citizen against central state will not be entertained by Supreme Court. Okay, so in this original jurisdiction, it should not be like that. If any person is lodging a case against central or state government, that will not directly come to the Supreme Court. So that is one point. And dispute that must involve a question of the legal existence and extent of the legal right depends. So basically, if there is tussle between the center and state government, if it contains any legal right issue, then that will come to the original jurisdiction, the Supreme Court. Further, that this original jurisdiction does not extend to a dispute which arises out of any pre-constitution treaty, like which happened between 1950, right, or agreement. If any dispute is arising of any treaty sector which specifically provide that state jurisdiction doesn't extend to such a dispute. Okay, if it says कि इसके extent में नहीं आएगा तो भी वो Supreme Court will not tolerate that. If it consists of any interstate water disputes, then also it will not come under the original jurisdiction of the Supreme Court. If there is matters which are referred to the Financial Commission, then again it will not come to Supreme Court. If there is adjustment of certain expenses and pensions between center and state, ओके कुछ एक्सपेंस और पेंशंस का कुछ एडजस्टमेंट है, वो केस आप सेंटर वो केस लेके आप एससी में डायरेक्टली नहीं आ सकते. इफ दिस ऑर्डिनरी डिस्प्यूट ऑफ कमर्शियल नेचर बिटवीन सेंटर एंड स्टेट, वो भी नहीं आ सकता. इफ दिस रिकवरी ऑफ डैमेजेस बाय स्टेट अगेंस्ट सेंटर, ओके कुछ डैमेज हो गया है ना स्टेट एंड इट इज आस्किंग फॉर द रिकवरी ऑफ डैमेजेस फ्रॉम सेंटर, देन ऑल्सो दैट केस कांट कम इनटू द original jurisdiction of the Supreme Court. So basically, if it contains something is written in Constitution or any of the act, and then you have to fight for that, then only that case will come into the original jurisdiction of the Supreme Court. So 1961, the first suit that was lost by the West Bengal Center on the validity of the coal bearing areas, the Acquisition Development Act. However, SC upheld the validity. SC ने क्या सेंटर के उसमें दिया होगा, but that was the first case, coal bearing areas में होगा, ठीक है. Then we come to the writ jurisdiction. So Supreme Court, by constitution, it guarantees and defends the fundamental right of citizens. Supreme Courts can issue writ including habeas corpus, mandamus, prohibition, quo warranto and certiorari for enforcement of the fundamental right. In this case, original jurisdiction आता है, as aggrieved citizen can directly come to Supreme Court. It's not exclusive because Article 226 as High Court को भी ये right देता है. But here disputes in this is between citizen and government, like a state. Citizen and government के बीच से तो jurisdiction का जो right है वो मिलता है Supreme Court को, original jurisdiction. Supreme Court can issue writs only for the encroachment of fundamental rights, but High Court can issue them for any other purpose. So High Court has wider power, but Supreme Court has High Court has wider power in this regard. Our Parliament can confer on Supreme Court the power of issue rates for other purpose. हाँ Parliament can बोल सकता है, but अभी के लिए इतना कुछ बोला नहीं है Parliament में, ठीक है. Now coming to the appellate jurisdiction. So Supreme Court has lot of appellate jurisdiction. Constitutional matters, civil matters, criminal matters, especially constitutional matter में any appeal can be made to Supreme Court against judgments of High Court. अगर High Court बोलता है कि it involves a substantial question of law that requires interpretation of the Constitution, तो वो Supreme Court में आ जाएगा. Civil matters में if High Court certifies कि that case involves a substantial question of law of general importance, Supreme Court में आ जाएगा, and that question needs to be decided by Supreme Court. If case involves substantial question or if question needs to be decided by the Supreme Court, then वो case Supreme Court में आ जाएगा. So originally cases involving a sum of rupees 20,000 would be appealed in Supreme Court, but monetary limit removed by 30th Constitutional Amendment Act 1972 में. तो पहले था कि सिविल जो केसेस थे उनमें अगर मॉनिटरी लिमिट कुछ मॉनिटरी कुछ लिमिट 20,000 की आ रही है, वही के सुप्रीम कोर्ट में आएंगे, बट वो लिमिट हटा दी गई थी 30th कॉन्स्टिट्यूशनल अमेंडमेंट एक्ट 1972 से. Now coming to the criminal matters, if High Court has an appeal reversed an order of acquittal of accused person and sentenced him to death. अगर किसी हाई कोर्ट ने किसी एक पर्सन का अपील जो है हाँ कोई किसी ने अपील करी होगी फॉर एक्विटल ऑफ एक्यूज्ड पर्सन एंड हाई कोर्ट ने उसको डेथ का दे दिया होगा, तो ही कैन गो टू सुप्रीम कोर्ट इफ ही सर्टिफाइज दैट ही इज नॉट, if it is fit to appeal to, if high court certifies ki now you can appeal to supreme court, then you can go. High court can take any cases from any subordinate court and convict. अच्छा high court ने कोई case subordinate का ले लिया खुद and then उसको convict कर दिया for the accused person, उसको death पे sentence कर दिया, though that person can go to supreme court. Okay. Appeal lies to Supreme Court as a matter of right and requires no certificate from High Court. So this first thing where acquittal. So in first case, which is like if any High Court has an appeal and it reverses an order of acquittal of accused person and sentence into that, in that case the appeal lies to Supreme Court as a matter of right and requires no certificate from High Court, क्योंकि उसने तो उसको convict कर ही दिया है, right? If any convicted has been ordered for acquittal of accused, then no right to appeal to. If any convicted has been ordered, okay, अगर किसी convicted को acquittal का वो दे दिया गया है कि छूट गया, बरी किया जाता है, तो फिर अपील नहीं कर सकते हो, उल्टे केस में कर सकते हो. अगर सेंटेंस ऑफ डेथ मिल गया देन यू कैन गो टू सुप्रीम कोर्ट, बट अगर डेथ से फ्री हो गया तो यू कैन गो. सो इन 1970 द पार्लियामेंट enlarged the criminal jurisdiction via appellate. Okay, बेसिकली अच्छा हाँ 1970 में तुम्हारा वो था ना, नहीं था 1970 में, और तो पहले कॉन्स्टिट्यूशनल एक्ट होगा पहले. सो 1970 में कोई एक्ट आया होगा तो उसने क्रिमिनल जुरिस्डिक्शन अपीलेट के थ्रू बढ़ाया होगा सुप्रीम कोर्ट का. If High Court on appeal has reversed an order of acquittal of accused person and sentenced him to imprisonment for life for 10 years, then he can go to Supreme Court. And same for case from the lower court, अगर उसने वहाँ से ले लिया है, वहाँ से life imprisonment का सजा सुना दिया है for the like from the High Court it has been given, तो फिर तो भी वो person जो है सुप्रीम कोर्ट जा सकता है. मतलब बेसिकली सेंटेंस ऑफ डेथ से 10 साल की जेल के लिए भी तुम सुप्रीम कोर्ट जा सकते हो. सो अपीलेट jurisdiction of Supreme Court extends to all civil crime cases in which Federal Court of India has jurisdiction to hear appeals from High Court, but which is not covered under civil and criminal appellate jurisdiction of Supreme Court as mentioned above. Sorry, appellate jurisdiction of Supreme Court extends to all civil and criminal cases in which Federal Court of India has jurisdiction to hear appeals from High Court. Appellate jurisdiction. Sorry. Now coming to the appeal by the special leave. The Supreme Court is authorized to grant in its discretion special leave to appeal from any judgment in any matter passed by any court or tribunal. What is saying? Appeal by special leave. Supreme Court is authorized to grant in its discretion a special leave to appeal from any judgment in any matter passed by any court or tribunal. ओके सो लेट्स से अपील बाय स्पेशल लीव में क्या होता है कि कहीं भी केस चल रहा है और सुप्रीम कोर्ट ने किसी पर्सन अपने पर्सनल डिस्क्रिप्शन पे किसी बंदे किसी जो भी केस करता है उसको स्पेशल लीव दे दिया है कि यू कैन अपील फॉर दैट जजमेंट टू सुप्रीम कोर्ट, देन दैट कैन कम टू द सुप्रीम कोर्ट except in military court cases and court martial cases. So basically this appeal by special leave, it's a discretionary power and hence can't be claimed, like matter of right nahi hai, discretionary power of the Supreme Court. It can be granted in any judgment whether final or interlocutor, मतलब in between judgment वाले केस में सुप्रीम कोर्ट खुद ले सकता है. It may be related to any matter, constitutional, civil, criminal, income tax, etc. It can be granted against any court or tribunal except military court. Okay. Scope of this provision is very wide and it vests the Supreme Court with a plenary jurisdiction to hear appeals, so should be sparingly used. मतलब वही है कि किसी भी तुम जजमेंट को उठा लिया, you can say now I will handle this, so दैट यू नीड टू टेक केयर, राइट? मतलब ऐसे रैंडमली कहीं भी नहीं यूज कर सकते हो. ओके. And so that is one thing कि अपीलेट जुरिस्डिक्शन में वी हैव डिसाइडेड सम केसेस ना कि हाई कोर्ट ने किसी बंदे को एक्विटल से हटा के 10 साल का जेल डाल दिया, या फिर किसी को लाइफ इम्प्रिजनमेंट कर दिया, या फिर हाई कोर्ट सर्टिफाई कर रहा है कि इट इज़ गुड फॉर लाइक नाउ यू कैन गो टू सुप्रीम कोर्ट. Apart from that, also all cases which come in the jurisdiction of Supreme Court, and he has the right to hear appeals from High Court, that can also come to the Supreme Court. Okay, that was the case of foreign jurisdiction. Now coming to the advisory jurisdiction. So Article 143, हाँ ये president वाला है, right? कि president कहाँ से advice ले सकता है. It authorizes the president to seek opinion of Supreme Court in any question of law or fact of public importance which has arisen or which is likely to arise, on any question of law or fact of public importance, or any dispute arising out of any pre-constitution treaty agreement. Okay, pre-constitution treaty पर कोई dispute वगैरह हो रहा है तो भी president can go to Supreme Court and ask for the advice. In first case, Supreme Court may refuse to give its opinion. Like first case was if कोई भी ऐसा law या fact of public importance maybe refuse कर सकता है opinion देने से. But in second case, Supreme Court is bound to give its opinion to president. In both cases, opinion is advisory. However, it facilitates the government to have an authoritative legal opinion on a matter. Yes, because they can at least say कि Supreme Court से हमने बात करी and they told me this. So for 2019, President has made 15 references to Supreme Court. लेकिन दिल्ली लॉज एक्ट जब होगा तो सुप्रीम कोर्ट के एडवाइस का यूज़ किया होगा. बेरूबरी यूनियन केस होगा तो भी सुप्रीम कोर्ट के लाइक एडवाइस यूज़ करी होगी. कावेरी वाटर डिस्प्यूट ट्रिब्यूनल जो बनी थी 1992 में, उस पर भी राम जन्मभूमि केस 93 में, 2G स्पेक्ट्रम घोटाला वाले 2012 पे. ठीक है. अदर पावर्स ऑफ द सुप्रीम कोर्ट इज द कोर्ट ऑफ रिकॉर्ड. Judgments, proceedings and act of Supreme Court are recorded for perpetual memory and testimony. Recognized as legal precedents and legal references. So उनके archives वगैरह सब रखा रहता होगा. It has power to punish for contempt of court either with simple imprisonment, 6 महीने का जेल भी दे सकते हैं, fine of 2000 or both. It can punish for contempt of court any high court subordinate and any court of India. तो Supreme Court can contempt of court में किसी को punish भी कर सकता है, 6 महीने का जेल या फिर 2000 का fine. Contempt of court may be civil or criminal. Civil contempt में willful disobedience of any judgment of order or writ or any process of court, or willful breach of any undertaking given to a court. तो फिर civil contempt हो जाएगा. Criminal contempt में if he scandalizes or lowers authority of any court, prejudices or interferes with due course of judicial proceedings, or interferes or obstructs the administration of judiciary in any manner. कुछ भी एडमिनिस्ट्रेशन जुडिशरी का अगर कुछ इंटरफेयर कर रहा है उसमें तो उसको क्रिमिनल कंटेम्प्ट में जेल में डाल सकते हैं. फेयर क्रिटिसिज्म ऑफ जुडिशरी इज नॉट कंटेम्प्ट ऑफ कोर्ट, दैट इज फाइन. ओके, नाउ कम्स द पावर ऑफ जुडिशियल रिव्यू. So to examine, it is given by the Article 13 of the Constitution, taken by American Constitution, to examine the constitutionality of the legislative enactment and executive orders of both central and state government. If it violates the Constitution, then it will be considered it is null and void. So constitutional interpretation का ultimate interpreter कौन होता है? Supreme Court. For the final version to the spirit and content of provisions of Constitution, Supreme Court is guided by few doctrines. First, the doctrine of बहुत सारे doctrines होंगे ऐसा तो. A doctrine of severability, waiver, precedent, eclipse, liberal. I actually don't know like कितना पूछते हैं इनसे, but बहुत सारे doctrines हैं जिनसे Supreme Court वो स्प्रिट लेता हुआ कि what actually our constitution maker wanted to convey by what they are written in the constitution. Other powers क्या होते हैं सुप्रीम कोर्ट के पास? It decides on the disputes regarding election of the president and vice president. In this regard, original, exclusive and final authority. Original appeal होता है सुप्रीम कि अगर कोई इलेक्शन अगर गलत तरीके से हुआ या फिर कुछ करप्शन का केस है उस इलेक्शन में, किसी पार्टिसिपेंट किसी जो खड़ा हो रहा है इलेक्शन में, इफ़ ही इज़ डूइंग एनी करप्ट प्रैक्टिसेस, तो भी आ सकता है उसमें. It inquires into the conduct and behavior of chairman and members of the UPSC on a reference made by president. If it finds any guilty, then recommend president for the removal. And that was binding on the president. Okay, if any president asks कि आप check करो conduct and behavior of chairman and members of UPSC, तो उससे उसके लिए बोल सकते हैं सुप्रीम कोर्ट चेक करो कि ज़रा गलत है, तो फिर उसको उसके ऊपर एक्शन लिया जाएगा. It has power to review its own judgment or order. Self-correcting agency, so its judgment. So let's say in गोलकनाथ केस में सुप्रीम कोर्ट ने कुछ कहा था 1967, and that has been reverted in the case of आनंद भारती केस. You can, in गोलकनाथ case, I think it was that case in which there was a difference between the law and constitutional amendment. तो सुप्रीम कोर्ट ने कहा था constitutional amendment doesn't come inside law, right? So parliament can amend that. In case of भारती case, they said कि no, that's also a kind of law, and if anyone is trying if parliament is trying to amend the constitution which is against the basic doctrine of the constitution, then basic structure of the constitution, then it will be declared invalid, right? It's ultra-vires, and that is the case. So then the Supreme Court is also authorized to withdraw the cases pending before High Court and dispose them. And the High Court case लेके I can do it. I can also transfer a case or appeal from one High Court to other. एक High Court से दूसरे High Court को दे दिया. Then its law is binding on all courts in India. Its decree and orders enforceable throughout the country. All authorities, civil and judicial, should act what is said by the Supreme Court. It has the power of judicial superintendence and control over all the courts and tribunals functioning in an entire territory of India. सबके ऊपर supervising superintendence का हक रहेगा तो केवल सुप्रीम कोर्ट के पास. Supreme Court की power and jurisdiction with respect to matters of union list can be enlarged by Parliament. It's up to Parliament what they can do. Supreme Court advocates, senior advocates, it is designated by Supreme Court or High Court. Supreme Court can designate any advocate with his consent as senior advocate if in its opinion, by virtue of his ability, standing at the bar or special knowledge or experience in law, he is deserving of such distinction. Senior advocate बना सकते हैं अगर बहुत काफ़ी साल से काम कर रहा है. She is not entitled to appear without an advocate on record or without a junior advocate. Okay, senior advocate will always come with an advocate on record or a junior advocate के साथ में. He is also not entitled to accept instructions to draw pleadings or affidavits or any drafting work in any court. Okay, मतलब ये छोटे मोटे काम थोड़ी करेगा. He is also not entitled to accept instructions to draw pleadings or affidavits or any drafting or any court, वो नहीं करेगा. Now second one, senior advocate वो होगा जो बहुत साल से काम कर रहा है ना. Advocates on record only these are entitled to file any matter or documents before the Supreme Court. Basically उसके अंडर वाला जो senior advocate वो फाइल करेगा कोई भी matter or document before Supreme Court, and they can also file an appearance or act from a party for a party. They can also file an appearance or act for a party. जिसका केस लड़ रहा है उसका केस वो सब डाल सकते हैं ना. And now come to other advocates. These are the advocates whose name are entered on the roll of अच्छा हाँ क्लैट के बाद एग्जाम होता है ना, नाल साल से लोग पढ़ के जाते हैं. तो एडवोकेट्स जिनका नाम कहीं भी किसी भी रोल ऑफ एनी स्टेट बार काउंसिल में इंटर्ड है बाय एडवोकेट्स एक्ट 1961, वो अदर एडवोकेट्स की लिस्ट में आ जाएंगे. एंड दे कैन अपीयर एंड आर्ग्यू एनी मैटर ऑन बिहाफ ऑफ द पार्टी. मतलब अपीयर एंड आर्ग्यू कर सकते हैं किसी भी पार्टी की तरफ से लड़ रहे होंगे. एडवोकेट तो कोई बन सकता है, बट दे आर नॉट इंटाइटल्ड टू फाइल एनी डॉक्यूमेंट ऑन मैटर बिफोर द कोर्ट. वो काम केवल एडवोकेट्स ऑन रिकॉर्ड कर रहेगा. जो भी लाइक वो आके लड़ सकता है अदर एडवोकेट्स लाइक विच आर जिनका नाम इंटर्ड इन द रोल ऑफ एनी स्टेट बार काउंसिल, दे कैन कम एंड फाइट द केस, बट दे कैन नॉट entitled to file any document or matter before the court. Now coming to the differences between the Indian Supreme Court and the American Supreme Court. Original jurisdiction is confined to federal cases in Indian Supreme Court. In American Supreme Court, the federal cases plus the naval forces plus maritime activities plus ambassadors etc. cases federal court में आएंगे. Federal court में आएंगे American Supreme Court, American Federal Court है ना. Okay. In Indian Supreme Court, its appellate jurisdiction covers constitutional, civil and criminal cases. In American Supreme Court, Federal Court, only constitutional cases. बाकी दोनों वाले जो है वो उनके जो state वाले court थे उसमें जाएगा. In Supreme Court, it has very wide discretion to grant special leave to appeal in any matter against judgment of any court except military. मतलब Special leave, then it has very wide discretion to grant special leave to appeal. You can appeal in the Supreme Court for any case against judgment of any court, तुम आके कर सकते हो except military. अमेरिकन सुप्रीम कोर्ट के पास ऐसा कोई पावर नहीं होता है, नो सच प्लेनरी पावर. इंडियन सुप्रीम कोर्ट के पास एडवाइजरी जुरिसडिक्शन होता है, अमेरिकन फेडरल कोर्ट के पास नथिंग लाइक दैट. इंडियन सुप्रीम कोर्ट का स्कोप ऑफ जुडिशियल रिव्यू इज लिमिटेड बिकॉज वो बेसिक डॉक्ट्रिन वाले चलते हैं, बेसिक फीचर ऑफ द कॉन्स्टिट्यूशन. अमेरिकन फेडरल कोर्ट वेरी वाइड जुडिशियल रिव्यू पावर. Indian Supreme Court defend right of citizens according to procedure established by law. American Federal Court follow the due process of law. Even that law जो बना है, right, वो law कैसे बना है उसका पूरा process American Federal Court can check. बट इंडिया में प्रोसीजर जो भी लॉ से एस्टेब्लिश हो गया वो फॉलो करना पड़ेगा. बट धीरे धीरे व्हाट आई सी कि इंडिया भी मूव कर रहा है फ्रॉम प्रोसीजर एस्टेब्लिश बाय लॉ टू ड्यू प्रोसेस ऑफ लॉ. इंडियन सुप्रीम कोर्ट इस जुरिसडिक्शन पावर्स कैन बी इनलार्ज्ड बाय पार्लियामेंट. अमेरिकन फेडरल कोर्ट द पावर हो जाए बाउंड कॉन्स्टिट्यूशन से. क्या बाउंड करो, जुडिशियल रिव्यू तो है ही है. इंडियन सुप्रीम कोर्ट कंट्रोल्स ओवर द स्टेट हाई कोर्ट ड्यू टू इंटीग्रेटेड जुडिशियल सिस्टम्स. अमेरिकन फेडरल कोर्ट नो सच कंट्रोल ड्यू टू डबल जुडिशियल सिस्टम. हम केवल कॉन्स्टिट्यूशन का काम देखेंगे, मिलिट्री काम देखेंगे. अमेरिकन फेडरल कोर्ट एंड उसके अलावा जो सिविल क्रिमिनल केसेस है वो तुम हैंडल करो. आई एम नॉट रिस्पॉन्सिबल फॉर दैट. दिस इज फॉर द अमेरिकन फेडरल कोर्ट एंड फॉर द सुप्रीम कोर्ट ऑफ इंडिया एज वेल. सो थैंक यू गाइज.